afternoon, everybody. Thank you to the trumpeter for that wonderful opening. I'm Liz Cohen. I'm delighted to welcome you to Radcliffe Day 2012, my first presiding as Dean of the Radcliffe Institute. Thank you. I spoke a few minutes last year, but this year it's mine. It's wonderful to see so many of the Institute's friends assembled here to celebrate Radcliffe and to honor this year's Radcliffe Medalist. Welcome to our Radcliffe College alumni, whose legacy is very much alive in the Institute's mission today, and whose loyalty makes possible so much of what we do. Welcome to our fellows, past and present, whose research and achievements exemplify the kind of transformative work that the Institute seeks to support. Welcome to the Harvard faculty, administrators, and students who have made their way across the road or across the river to join us in Radcliffe Yard. Welcome to the members of our Dean's Advisory and Schlesinger Library Councils, as well as to the members of the former Radcliffe College Alumni Association. Welcome to our friends from the Harvard Alumni Association, particularly Ellen Gordon-Reeves, president of the HAA, who has helped Radcliffe make many new connections this year that will last well into the future, even though Ellen's term as president is ending shortly. Welcome also to Carl Muller, who will become the new head of the HAA in July. I look forward to working with you. Welcome to those of you joining us online via our live webcast, an important first for Radcliffe Day, and a wonderful example of the broad global audience we are engaging through new technology. I am particularly pleased to welcome former Radcliffe President Linda Wilson and the two past deans of the Radcliffe Institute, Drew Faust and Barbara Gross. Today is an historic gathering of almost a quarter century of Radcliffe leaders. A special welcome as well to our speakers from this morning's fabulous panel discussion at the ART. Martha Minow, Renee Landers, Jennifer Gordon, Linda Greenhouse, and Kathleen Sullivan. They really were fabulous. And of course, welcome to Margaret Marshall, former Chief Justice of the Massachusetts Supreme Judicial Court, whose life and career we honor today with the 2012 Radcliffe Medal. I am delighted to tell you that we have with us today 5 women judges, some of them alumni of Radcliffe, here to pay tribute to Chief Justice Marshall. I would like to take a moment to also welcome and recognize some of our audience who are marking Radcliffe milestones this afternoon, in particular our reunion classes. Members of the class of 1987 who are celebrating their 25th reunion. The class of 1962 who are celebrating their 50th reunion. And the class of 1942 who are celebrating their 70th reunion. So this should be an incentive to keep coming. The older you get, the louder the applause. Welcome also to the other reunion classes, 1982, 77, 72, 67, 57, 52, and 47. And congratulations to the earliest classes with representatives here today, the classes of 1936 and 1939. Those of you who were here with us last year may remember that I mentioned that my own mother-in-law, Catherine Eaton Chapman, was a member of the class of Radcliffe 36. Please join me in welcoming all of our milestone alumni. I am mindful, too, that there are many in our Radcliffe family who are missing from this celebration. Please join me in a moment of silence as we remember those college alumni, Bunting and Institute fellows, and friends who are no longer with us. Now I would like to welcome to the podium an old friend of Radcliffe's and a very dear friend of mine who would like to say a few words. Please join me in giving a warm welcome to Harvard President Drew Faust.
Thank you. Thank you very much. Thank you. I have so many happy memories of Radcliffe days in this tent, looking out at all of you and introducing the speaker and talking about what we've done at the Institute the previous year. So it's a treat for me to be back here speaking with you today. There's a tradition or a custom, I don't know exactly which way to describe it, at Harvard, that when a new dean is appointed, I take that dean to her or his school and present the individual to the faculty and students and assembled members of the school. And we did this earlier this spring, but it seemed to me appropriate to present the new dean to this group of alumni and friends of Radcliffe as a ritual of transition and also as a time when we all expressed to her our commitment and support to her success and the success of the Radcliffe Institute. I would guess that 2 years ago at this time, Liz Cohen had no notion of being the dean of the Radcliffe Institute and no thought that she actually would ever be lured away from her extremely important scholarship to undertake a leading administrative role. When I asked her if she would be interim dean, she was kind of intrigued and thought this would be, interesting to try for a year. But as she delved deeper and deeper into the role, into what it had to offer, and into the wonders of the Institute itself, she began to become more and more interested in what she was doing. And at the same time, a search advisory committee working with me was becoming also more and more interested in what Liz was doing. Happily, the intersections of these interests took place in the spring, and I was able to have the great privilege of asking Liz if she would become the permanent dean. We are very lucky to have persuaded her to do this, and also I think lucky because it came out of the excitement she found in bringing people together, bringing ideas forward, sponsoring events like the wonderful panel that happened this morning, which, alas, I was not able to attend, but have heard so much about, and I hope maybe there's in accordance with your new procedures, Liz, a video and so forth, so I will get to see it in a delayed form. But Liz's energy comes, I think, out both of her deep intellectual curiosity, which is a perfect characteristic for the dean of the Radcliffe Institute, a place that's supposed to bring together all fields of learning as well as the arts, which are of particular interest to her. That intellectual curiosity combines with a formidable energy that you all have been exposed to already, but that I think will serve the Radcliffe Institute and Harvard University so well. She is a prize-winning, acclaimed historian of the United States, and particularly of the urban structures of the United States in the 20th century, with a deep interest in the built environment, in architecture and design and urban planning. She is also an accomplished teacher, beloved by her students, and a person who is going to serve this institution so very well. I'm also delighted that she will be serving Harvard more broadly and will bring her perspectives and those of the Institute to the broader councils of university leadership and governance. So please join me in welcoming officially Liz Cohen and committing ourselves to her success and her very good time as Dean of Radcliffe Institute.
Well, I'm going to hold you all to this pledge to be there to help me, so you're not going to get off. Okay, we've moved on here. So many thanks, Drew. I would like now to share with you some of this year's activities, as well as look briefly into the future. I feel very lucky as a new dean to be building on the Institute's 12 years of success, due in large part to the dynamic leadership of Drew and Barbara, a success built on the extraordinary foundation of Radcliffe College. Much of what I see for the Radcliffe Institute's future is, in fact, an extension of the things you have long valued at Radcliffe. We are dedicated to supporting advanced work in all academic disciplines and the arts, with a special commitment to the study of women, gender, and society. We strive for excellence in all academic inquiry and are then committed to sharing that new knowledge with a broad public audience through our library, our exhibitions, and our extensive public programming. In fact, we like to think of ourselves as a front door to Harvard, open, accessible, and welcoming to all. I think I can confidently say that 2011-12 has been a banner year for the Institute in realizing its mission. We have had a fabulous group of fellows, some of whom are here with us today, in a stunning variety of fields. The Schlesinger Library has flourished, actively collecting traditional manuscripts while increasingly gathering what is called born digital material, which includes emails, blogs, and websites, and experimenting with new ways of digitizing its collections to make them more accessible to researchers. We have supported the early stage research of Harvard faculty and former fellows by hosting 24 exploratory seminars and workshops that they have proposed. We hosted conferences on cutting-edge topics, ranging from the role of women in movements for democratic change, such as Arab Spring, to the mechanics of naturally occurring and synthetic molecular motors, to new possibilities for strengthening the relationship between cities in general, and Boston in particular, and the university. Our public lectures brought speakers like public figure Anita Hill, historian Anthony Grafton, filmmakers Deepa Mehta and Fred Wiseman, and scientist Nicole Le Duharin to talk about their work. We had record crowds at many of these events, and we were also able to broadcast several of them on the web, expanding our audience beyond those who could join us physically here on campus, and allowing visitors as far away as New Zealand to witness firsthand the kind of work that goes on every day at the Radcliffe Institute. And we brought Radcliffe on the road to many of you, with special events in New York, San Francisco, Palo Alto, and Chicago, designed to give our friends in other cities a taste of our public programming. It has been wonderful to see so many supportive faces at those events around the country, and I hope that you will join us for one next year as we take more of our programming to new destinations. Planning for 2012-13 is well underway, and I'm delighted with what we have in store for you. I hope that you saw our recent press release about next year's fellows. They are an impressive, diverse group, and all of us at the Institute are looking forward to learning more about their work and getting to know them. Please check our website for details on more lectures and conferences in what promises to be a dynamic year of events. I want to mention just one in particular so that you can mark it on your calendars. On Friday, September 21st, we will kick off the academic year with a symposium entitled Citing Julia, which will celebrate the life and work of Julia Child, whose papers the Schlesinger Library proudly holds. Julia would have turned 100 this summer. More information about Citing Julia is available in the latest issue of the Schlesinger Library newsletter, which is hot off the press. Here it is, got one here, and there will be more of them available in Fay House if you go there after the lunch. I just want to say that I am truly delighted with the Fay House renovation. It meets our needs for a pleasant, modern office space while also respecting something that matters to me a lot, the historical integrity and dignity of the building. You will notice as you walk through the space that although we have updated some features of the house with a particular eye to making it a green building, we have restored some historic spaces and features and brought back the antique furniture, the rugs and paintings, many of them gifts of alumni, so that they can continue to provide warmth and a domestic character to Fay House. The new landscaping that you'll see around Fay House signals the final stage of the Radcliffe Yard renovation. First the Schlesinger Library, then the Radcliffe Gymnasium, Byerly Hall, and now Fay House are complete. Next week, we will begin a major re-landscaping of the yard to improve the health and design of the Institute's grounds. You must come back next year to see it all done. And I have good news for you. Next year, Radcliffe Day is the Friday after, not before, Memorial Day weekend. What you may not immediately notice when you walk through Fay House is the building's new state-of-the-art audiovisual technology that allows us to bring our programming to Radcliffe audiences around the world. Video conferencing that will allow scholars and experts from afar to participate in seminars and discussions here at Radcliffe, and video capabilities that will optimize our audience at public events by live webcasting as we're doing today, and then posting these programs on the website. Now you and our other friends outside of Cambridge can attend a lecture or a conference even if you can't make it here to campus. I hope you will join us online for many of the stimulating events that we have planned for next year. And this brings me to another very exciting development that I want to tell you about here at Radcliffe. We are very proud to have just unveiled a brand new website. The new site brings the Institute firmly into the 21st century and is the launching pad that we need for a more dynamic web presence that reflects the vibrancy of the people, places, and collections at the Radcliffe Institute. I want to draw your attention to two features of the new site built with you in particular in mind. You will see on our new homepage that there is an alumni tab. Consider this your new hub for all things Radcliffe. The alumni pages include the digitized Radcliffe College archives and details about alumni events on campus and around the country. Also, you may have heard that this April we hosted a lecture by Helen Horowitz, Professor Emerita at Smith College, titled "It's Complicated, 375 Years of Women at Harvard," in honor of Harvard's 375th anniversary. The event page on our website for It's Complicated features video and transcript of Helen's talk, along with links to press coverage of the lecture. After today's lunch, you can watch the video, or some piece of it, of Helen Horowitz's lecture in the sheer room on the first floor of Fay House. And when you're there, I hope you'll have the opportunity to view an exhibition that the Schlesinger Library curated to accompany Helen's lecture, which includes fascinating documents and photographs from the library's holdings illuminating the history of women at Harvard. I hope you will take some time to explore these materials, either on the website or in the sheer room. They document the history of women at Harvard, a history that each of you has helped to create. The Radcliffe Award, the Radcliffe Medal, is awarded annually to an individual whose life and work have substantially and positively influenced society. This year's medalist, Margaret Marshall, is an exemplary recipient. Her work as Chief Justice of the Massachusetts Supreme Judicial Court has transformed society, not only in this state, but across the nation. And her long history of activism will have a lasting impact on the world we live in for years to come. Margaret Hillary Marshall, known to all as Margie, was born in apartheid South Africa, in a coal and steel town called Newcastle, the daughter of an industrial chemist and a homemaker. Margie was aware from a very early age of the injustice of apartheid, that she was able to travel and to learn and to work wherever she wanted to, while Black South Africans could not. That awareness solidified into a passion for activism when Margie traveled to Detroit as a high school exchange student in 1962. She was amazed by the freedom Americans had to criticize their government, and she was inspired by the civil rights organizing she saw exploding around her in the early 1960s. She brought these ideas home with her when she returned to South Africa and started university, studying art history. In college, Margie joined the National Union of South African Students, an organization dedicated to ending apartheid and in time, she became its president. Although Margie's political activism was more pacifist than militant, she led vigils, she collected signatures, she raised money. Still, she was threatened as a leader of the Union. Her phone was tapped, and she was followed. Supporters raised funds to send her back to the United States for her protection. We can be proud that when Margie Marshall returned to the United States, she came to Harvard. She enrolled at the Graduate School of Education with a full scholarship, an accomplishment in itself for a young woman who was one of only a few girls from her high school to attend college, let alone consider an advanced degree. She stayed in the US after receiving her Master of Arts degree in 1969, well aware of the dangers of returning to South Africa. In fact, she was unable to visit her home country for decades because of her known opposition to apartheid. At the Harvard Ed School, after the Harvard Ed School, Margie traveled around the US organizing support for the South African cause in churches and in schools. In 1973, a new path beckoned, and Margie entered Yale Law School. At first, to learn more about the American legal system. In time, to earn a JD degree, to practice law, and to commit herself to perfecting that rule of law that she had come to admire so much as a political refugee from her own country. Shortly after graduating from law school, Margie Marshall began work in the law firm Sapler & Bach, helping to build that firm's litigation department. And in 1989, she became the first woman to join the litigation group at Choate Hall & Stewart, specializing in intellectual property. Even during Marshall's years in private practice, she retained her idealism. She stressed the importance of activism and volunteer work, such as her own involvement with the Boston Bar Association, and she mentored young women to succeed in the legal profession. During the year that she served as president of the Boston Bar Association in 1991, she promoted family-friendly policies that were beneficial to other women lawyers. In 1992, Margie made a career shift when Neil Rudenstein, then president of Harvard, named her general counsel of the university. Margie was the first woman to take on this role, and by all accounts, she demonstrated enormous tact, discretion, and loyalty, along with her great intelligence. But Harvard was not to have the benefits of Margie's talents for long. In 1996, Governor William Weld appointed her an Associate Justice of the Massachusetts Supreme Judicial Court, making her only the second woman to serve on the state's highest court in its more than 300-year history. Within 3 years, her impressive performance propelled her to even greater heights when Governor Paul Cellucci named Margie the 24th Chief Justice of the Supreme Judicial Court. On October 14, 1999, Margaret Marshall became the first woman ever to hold the highest judicial position in the Commonwealth of Massachusetts. Marshall's time as Chief Justice was, I think we can all agree, an extraordinary era. Over 14 years, she authored more than 300 opinions, and she oversaw dramatic reforms of the Massachusetts court system, such as decreasing a crippling backlog of cases in the courts, reducing the political interference in court hiring, and expanding services and resources for people representing themselves, coping with language difficulties, or struggling with limited financial resources. Marshall has been adamant that her opinions as Chief Justice were constitutional rather than political, but there is no doubt that many of those decisions were made in the face of political controversy. One case defended the rights of Walmart employees to challenge their employer for withholding compensation and denying or limiting entitled breaks. Another recognized the legal status of a de facto parent, affirming a visitation order between a child and the maternal aunt who had raised her as being in the best interests of the child. And still another concluded that cigarette manufacturers could not use the excuse that smokers knew their use of cigarettes to be unreasonable as a line of defense in cigarette-related product liability actions. But perhaps Marshall's best-known opinion is Goodridge v. Department of Public Health, authored in 2003, which made Massachusetts the first state to recognize the right of same-sex couples to marry, an opinion which has aptly been called a pen stroke heard around the world. That decision asserted that no less than full equality in marriage rights would satisfy the Massachusetts Constitution. It was a decision that changed forever the conversations happening nationally about the definition of marital relationships. And one reason that Marshall's opinion was heard so clearly around the world was that it was so easily accessible. Written in clear, direct language, it has in fact emerged as a foundational text delineating the nature of marriage, and it's frequently quoted in wedding ceremonies both by homosexual and heterosexual couples alike. Goodridge v. Department of Public Health has clearly had an enormous impact, but Marshall has maintained that every case she decided carries the same weight, the same significance. For me, she has said, every case has that importance, and you learn as a judge that certain cases spark interest and others don't, but the legal issues are important in each case. When Chief Justice Marshall announced her decision to retire in July 2010, our Governor Deval Patrick said, and I quote him, "Chief Justice Marshall has served the people and the principles of this Commonwealth with exceptional integrity and grace. Her dedication to the rule of law and the defense of human dignity is timeless," end quote. Margie Marshall's deeply rooted passion for a more just society makes her an ideal candidate for the Radcliffe Medal, and I'm honored that we have the opportunity to pay tribute to her today. But first, I cannot leave her story there. In inimitable Margie fashion, she has begun a new chapter. After a very short retirement break, Margie Marshall has rejoined the work world, reaffiliating with Choate Hall & Stewart to focus on community outreach, pro bono initiatives, and diversity programs, and she has become a senior research fellow and lecturer at Harvard Law School so that she can help educate future lawyers about judicial independence, judicial ethics, and the First Amendment. In a world where so many people are eagerly seeking a chance to live in a more law-bound, constitutionally protected, equitable, democratic society, and yet there are so many obstacles to getting there, a thinker, a doer, and an educator like Margaret Hillary Marshall, who is so committed to making the law work in behalf of ordinary people, is a Radcliffe, indeed a national treasure. And I am thrilled to announce today that Margie is giving the Radcliffe Institute another treasure. We are honored that the Schlesinger Library will receive Margie's papers to be included in our collections documenting the lives and work of women in America. So now please join me in welcoming to the stage Chief Justice Margaret Hillary Marshall. Okay. Chief Justice Margaret Hillary Marshall, we honor you today with the 2012 Radcliffe Institute Medal for your dedicated service to the Commonwealth of Massachusetts at its highest judicial authority, your unwavering commitment to the rule of law, and your passion for justice and equality around the world. Is yours, which you can take. And now it's her show.
Gosh, what a wonderful, wonderful introduction, Liz. And I'm a little breathless, so I'm just going to take a moment to find my way to my pages. So first, Dean of the Radcliffe Institute for Advanced Studies. I just love that name, Dean Cohen. Former President Linda Wilson, former Radcliffe Dean. Barbara Gross, former Radcliffe Dean. and our president of Harvard University, through Faust, and friends all, and there are so many friends here today. What a privilege it is for me to be standing here. I have attended this annual lecture for many years, and for me it is always a highlight of the commencement season, this wonderful time of year when generations of students leave to commence their adult lives, enriched, we hope, by teachers who have imparted to them the values of openness, curiosity, critical analysis, and deep respect for the dignity of others, respect for the diversity of people and the diversity of ideas, and the courage to question. Second, coming to this annual luncheon reminds me always of the extraordinary women, many of whom are here today, on whose shoulders women of my generation and younger now stand. We could never, never, never have accomplished whatever we have without the fighting spirit, the sheer bloody-mindedness, and the decades of relentless struggle of those women who refuse to accept that we are less than men, and who worked tirelessly to tear down every arbitrary barrier in the path of full equality of women. And so I pay tribute to the many classes here as long as you are before the class of 1962. This afternoon, even as we share this wonderful time together, and even as we celebrate all that women in the United States have achieved since Radcliffe was founded at the end of the 19th century, I want to share with you some concerns that I have about these United States at the beginning of the 21st century. And to do so, I want to turn back to what Liz talked about, a little bit of my beginnings in Newcastle, a small village in the foothills of the Drakensberg Mountain, that great spine of mountains that run north to south through one of God's special gardens, South Africa. As Liz said, I was born and spent my childhood in what Nobel Prize winner Nadine Gordimer has called the, quote, rigidly racist and inhibited colonial society of small-town provincial South Africa. Today, when I use the word apartheid, I wonder whether my audience really know what it meant to live in that system of racial intolerance. You surely understand that South Africa's apartheid laws had one primary aim: to protect and consolidate the power of the powerful. You surely know that teachers and doctors and lawyers were imprisoned and tortured or forced to leave the country as often because of the views they expressed or the ideas they held. And you surely comprehend that women and men were treated as subhuman simply because of the color of their skin. Apartheid, an entire sophisticated modern industrial society tethered by law to the idea that whites are superior in every respect to blacks. The existential blindness of white South Africans to apartheid was banal, quotidian, and almost universal. How could white South Africans not see, I am asked, and more penetratingly, what took you on the path from that isolated village to the Supreme Judicial Court of Massachusetts? The answers to those questions are many and complex, but two things have had a profound influence on my life, both of which were touched on by Liz. First, a liberal education that brought me here to the United States. And second, the discovery again here in the United States that an alternative, a real alternative, existed to the rule of brute power that I had experienced in South Africa. Education, I came in 1962 to Wilmington, Delaware, as a high school exchange student. And Liz had already described the impact that had on me. I could read books that were outlawed in my own country. I read Alan Paton's Cry the Beloved Country, and for the first time learned of the long struggle for freedom in my own country. education, for the first time, I felt free to roam through the marketplace of ideas and to speak my mind and to change my mind. The social arrangement of apartheid, the lens through which I had been taught to view all social relations, revealed itself as a distorting prism of terror and fear. And when I returned home to South Africa, I was wearing a new pair of glasses. And 10 years later, turbulent and challenging years for me, I found myself back in the United States at Yale Law School. The United States, of course, is committed to the ideal of equal justice under law. And here I saw the rule of law, the rule of democratic law in action. It opened school doors for black children, it dislodged a president for abuse of power, and it gave women control over our bodies. What I learned at Yale gave structure to the ideals I had yearned for in South Africa, a just society, a society founded on the rule of law. A liberal education, free, quality public education, and the rule of democratic law, equal justice for all, these two pillars of American life have drawn millions to our shores and continue to do so. And so it has been for me, for this country has more than fulfilled the promise of our nation's founders. They well understood that a government of laws and not of men, and I quote there from the Massachusetts Constitution, could not long exist without an educated public. Wisdom and knowledge diffused generally among the body of the people, said John Adams, the drafter of the Constitution, are necessary for the preservation of their rights and liberties, and these depend on spreading the opportunities and advantages of education in the various parts of the country and among different orders of people. John Adams. Spreading the opportunities and advantages of education and preserving the rights and liberties of all have made the United States a great nation. But I have concerns, deep concerns, for the country I have come to love and call my own. Through my work as Chief Justice of Massachusetts, I have seen firsthand that education, our schools, and justice, our courts, are in danger, real danger, of failing their critical missions. Time does not allow me to talk today about the problems of our schools. My remarks will focus on the threats to the second pillar of our American democracy, fair and impartial courts. Every day in courts across this Commonwealth, judges give meaning to the command of the Massachusetts Constitution, the oldest written constitution in the world. Quote, "It is essential to the preservation of the rights of every individual, his life, liberty, property, and character, that there be an impartial interpretation of the law and the administration of justice." It is essential that there be an impartial interpretation of the law and administration of justice. Could anything be more compelling, more foundational to our democracy than the constitutional command that judges be impartial? Not so, it appears, to a wide swath of political leaders and pundits, and not so, it appears, to some justices of the United States Supreme Court. To the contrary, today we are witnessing a full-scale assault on the foundational notion that judges should decide cases on the facts and law alone. Increasingly strident politicians have been taking to the airwaves, arguing that judges should not be neutral, should not be impartial, but should check the opinion polls before they issue a decision. The assaults are not confined to a few state legislators who file bills to jail judges for unpopular opinions, and there have been such legislation. The assaults are being mounted at the highest levels. One recent candidate for President of the United States ran on the promise that if elected, he would ignore the holdings of the Supreme Court decisions with which he disagrees. I'm fed up with the elitist judges who seek to impose their radically un-American views, the candidate said, and proposed to subpoena judges to appear before Congress to answer for unpopular decisions. Another presidential candidate believes that Congress should exercise a legislative veto over Supreme Court decisions. Congressional leaders have vowed to punish, and that is their word, punish judges for unpopular opinions. This is not good faith criticism of a court decision, a judge, or judicial philosophy, all of which are welcome and necessary in a robust democracy. This is demagoguery, plain and simple. Of particular concern to me is the manner in which the First Amendment is being used as a Trojan horse by those who seek to undermine the notion of impartial justice. Would that I could tell you that the United States Supreme Court is acting to forestall this. To the contrary, a majority of the justices are leading the charge. Republican Party of Minnesota against White, a 2002 decision. 47 states elect some or all of their judges. At issue in the White case was whether a provision of the Minnesota canons of judicial conduct, those are the ethical rules that judges must follow, violated the freedom of speech guarantee of the First Amendment. That rule prohibited candidates for judicial office from announcing their views on disputed legal or political issues. And the Supreme Court held in essence that the First Amendment rights of judicial candidates to announce their opposition to abortion, for example, or in favor of the death penalty, trump the state's interest in preserving the impartiality of the judiciary by restricting those statements. Most disturbing in that case is the short shrift given by the court to the very notion that judges must be, or even can be, impartial. On this point, Justice Scalia, writing for the court, is nothing short of contemptuous. Under settled First Amendment analysis, Minnesota, the state, was required to demonstrate that its announced prohibition was necessary to protect a, quote, compelling state interest. A compelling state interest is the standard that must be established to defeat a First Amendment challenge to a government rule, such as the judicial canons were. And Minnesota had taken the position that the announced prohibition helped preserve the impartiality of its courts, which it argued was a compelling state interest. Methinks that John Adams would readily have agreed. Not so our Supreme Court. Noting that Minnesota did not bother to define, those are the court's words, impartiality, Justice Scalia suggests his own. Perhaps he muses impartiality means the lack of bias for or against a particular party in a particular legal proceeding. Certain, he writes, a party who takes a legal position against one previously announced by the judge, quote, is likely to lose. Those are Justice Scalia's views, likely to lose. No problem with that, he concludes, so long as any party taking that position is likely to lose, the judge is applying the law even-handedly. I could not disagree more strongly. In my experience, judges, other than the most driven ideologues, try to place aside and succeed in placing aside their personal views, announced or not, in deciding what the law, impartially applied, requires. It troubles me deeply that our nation's highest court claims otherwise. Or suppose, writes Justice Scalia, impartiality means a, quote, lack of preconception in favor of or against a particular legal view. This, he says, is not a compelling state interest that could justify restricting the speech of a candidate for judicial office. No judge is a blank slate, and, quote, pretending otherwise by attempting to preserve the appearance of that kind of impartiality can hardly be a compelling state interest either. Justice Scalia seems intent on giving license to those who would impose their own particular legal views on litigants who come to our court seeking an impartial interpretation of the law. Last, Justice Scalia considers whether Minnesota's rule was designed to protect open-mindedness, a judge's, quote, willingness to consider views that oppose his preconceptions. This sort of impartiality, he says, seeks to guarantee each litigant, pay attention here, not an equal chance to win the legal points in the case, but at least some chance of doing so. This type of impartiality and the appearance of this type of impartiality may be desirable, he concludes, but nothing more. What a crabbed, narrow view the United States Supreme Court has articulated of the constitutional promise of unbiased courts of impartial judges, and to devastating effect. Perhaps you think I am being alarmist. The justices in dissent, Justices Stevens, Ginsburg, Breyer, and Souter, would disagree, and history has confirmed their judgments. Justice Stevens excoriated the majority for, quote, obscuring the fundamental distinction between campaigns for the judiciary and campaigns for the political branches based on a flawed and inaccurate appraisal of the importance of judicial independence and impartiality. And for Justice Ginsburg, quote, when a judicial candidate promises to rule a certain way on an issue that may later reach the courts, the potential for due process violations is, in her words, grave and manifest. And I agree. The White decision has opened a Pandora's box of noxious influences on the principle and the reality of fair, impartial justice in our state courts. Lower federal courts have relied on White's First Amendment analysis to strike down other rules of judicial ethics aimed at ensuring the integrity of our courts. The so-called pledges, promises, and commitments rule that prohibits judges and judicial candidates from promising in advance to decide certain cases in a certain way, rules prohibiting judges from personally soliciting campaign donations, and rules restricting judicial candidates from engaging in partisan political activity. All are gone in the wake of White. Implicit in our constitutional compact is the guarantee that judges will give each person a fair hearing, will consider only the evidence presented in court, and will not look outside the courtroom to reach a decision. White and its progeny, which privilege the speech of judicial candidates over the integrity of courts, strain this compact to the limits. And the results, pretty much what you would expect. In many jurisdictions, judicial candidates now ardently commit themselves to rule a certain way on issues that may come before them. They publish deliberately misleading statements, attack ads, and slur campaigns about their judicial opponents, and a judge who can send a litigant to jail for lying may have become a judge by doing no less in his own political campaign. Of course, it takes money to fund an attack ad. In recent years, special interest groups have been pouring millions of dollars into judicial campaigns to elect a judge amenable to their interests. Another predictable result, quote, the crisis of confidence in the impartiality of the judiciary is real and growing. Left unaddressed, the perception that justice is for sale will undermine the rule of law that courts are supposed to uphold. Those are the words of Justice Sandra Day O'Connor, who has been sounding the alarm across this country. 3 out of 4 Americans, she said, believe that campaign contributions affect courtroom decisions. The Supreme Court's much criticized 2010 opinion, Citizens United Against Federal Election Committee, adds oil to the fires already burning in state judiciaries across the country. Almost all of the commentary, and certainly the commentary in the electronic media, has focused on the consequences of that decision for presidential and congressional races. The less heralded consequences for judicial elections are even more troubling, as Justice Stevens noted in his powerful dissent. Today, he wrote, the court unleashes the floodgates of corporate and union general treasury spending on judicial elections. States, he said, quote, may no longer have the ability to place modest limits on corporate electioneering, even if they believe such limits to be critical to maintaining the integrity of their judicial systems. The backlash against Citizens United has been as fierce as the opinion itself was radical, and perhaps that is a hopeful sign. One state has already tried to rein in the harm. Last year, the Supreme Court of Montana essentially repudiated the rationale of Citizens United as applied to Montana, finding that Montana's restrictions on direct spending by corporate entities was appropriate under the First Amendment. The reason? Because the court said the people of Massachusetts have the right, the people of Montana had the right to uncorrupted government where each individual's vote counts. As for the judges, the Montana court held that the state had, and I quote, remember the words, a continuing and compelling interest in protecting and preserving the people's constitutional right to an independent, fair, and impartial judiciary, a compelling state interest to protect that right. Is it too much to expect the United States Supreme Court to say the same? The fate of the Montana case is uncertain. The Supreme Court is considering whether to grant review in the case. What is clear is that Citizens United bodes ill health for the health of state judiciaries that elect their judges, which are already awash in a torrent of special interest money. Harsh state judicial campaigns financed by even larger amounts of special interest money are eating away at public faith in judicial impartiality. An editorial in the New York Times concluded, "Can anyone be surprised?" Constitutional democracy, although surely imperfect, is the best mechanism we have to ensure that debates about deeply divisive national issues will take place according to the rule of law and not the law of the ideologue or the law of the mob. In a speech at Georgetown University widely reported in this country and abroad, Justice Sandra Day O'Connor voiced concern about the efforts of those who would strong-arm the judiciary into adopting their preferred policies. It takes a lot of degeneration before a country falls into a dictatorship, she said, but we should avoid these ends by avoiding these beginnings. Justice O'Connor is not known for hyperbole. I return to my beginnings. I grew up in a country where the government controlled the courts, where judges were powerless to declare law passed by the apartheid parliament to be inhumane, oppressive, or discriminatory. Do we here in this great country really want a legal system where judges write for popularity and not for justice? The warning signs are there for all to see. The question is, have we the will to protect the structure of government that for so long has protected us? Thank you.
So I want to thank, I know you too want to thank Margie Marshall for these very inspiring, if disturbing, remarks. And we take an important message away with us today, thanks to you. I want to thank you all for coming to Radcliffe Day 2012, and I look forward to seeing you again at Radcliffe Day 2013 on May 31st.